Former Prime Minister Paul Keating has taken a swipe at the Native Title Act. He says it's unjust, with too much emphasis placed on Indigenous land claimants proving continuous occupation. Mr Keating says only a fraction of claims have been settled, despite a cost to taxpayers of around $1 billion.
Former Prime Minister Paul Keating says efforts to address a brutal dispossession have been slow and at times unfair. One reason for that, he says, is the onerous burden of proof to prove continuous occupation of land.
Native title should not be viewed as some museum-like strain of law, which, snap frozen, requires defrosting around anthropological principles, documentary records that rarely exist, if they ever existed.
And now one of the country's most senior Indigenous leaders, Lowitja O'Donoghue, would also like to see change.
It's very difficult, of course, for those urban people, more than the people in remote areas and so on, who continue to remain on their land and practice the traditions and so on.
According to Mr Keating, in the first 15 years of the Act, 1,300 claims were lodged, but only 121 cases were determined, covering 10% of Australia. The cost to taxpayers was $900 million.
The amount of research, the amount of resources that go into this process is alarming.
The federal government says 157 claims have been resolved, and changes to federal court powers are speeding up the process.
We are reluctant to do anything that is going to re-enliven new legal issues that may prolong rather than reduce the time spent in litigating these matters.
The Attorney-General says he's hoping that the bulk of outstanding claims will be resolved in the next 2 years. Philippa, McDonald, ABC News.